going live on all our social media. Hi, everybody. My name is Attorney Michelle Perez. I'm one of the co-founding attorneys here at Saavedra Perez. We're going live on all our social medias, which would be Facebook, Instagram, YouTube, and TikTok. So I'm here to answer any questions that you may have and any immigration questions that you may have. We're here live every day to help the community answer any questions, offer advice. Um, and if you have maybe a situation and you would like a full consult, our consultations about 30 to 45 minutes. We go over your entire history with you, see what kind of case you can have and what we can do for you. Um, I've talked to recently a few potential clients in the last couple of days, and they told me that they realized that they have a lot of fear talking to attorneys. One can be that they learn the truth, right? They learn that maybe there isn't relief for them. Or two, they think they know about T visa, VAWA, U visa, and maybe they don't feel like they want to go down that route because maybe they don't want to harm their U.S. citizen spouse in any way doing a VAWA, or maybe they don't want to harm their family member in any way by doing like a T visa. And so I'm here to let you know, like, the best thing that you can do is get informed. So having a consultation with us allows us to review your case first, see if you have like a VAWA, T visa, or maybe you have like a simple AOS marriage and you're trying to adjust your status based on a marriage to a US citizen. We can determine that by just talking to you for 30 to 45 minutes and really get to know your story. Um, Once we get to know your story during a consult, we can then let you know if we're able to help you, what the process is. And when we do that, we are completely honest with you and we tell you what we believe is the strength of your case, or maybe your case isn't as strong, and we'll let you know, but you can still try. And si hablas español, mi español no es perfecto, pero si tiene algunas preguntas en español, sí puede poner un comentario por bajo y puedes responder también. Okay, we have a few questions coming in. So, hi, I have a T visa approved and a U pending. Can I still add my new husband? That is a really good question. So, for the T visa, because it's already been approved, you cannot add your husband. Your U visa, however, you can add your husband. Now, the problem that creates is that if you are no longer eligible for a U visa because maybe you have adjusted your status to a resident with your T visa, they will cerrar or close your U visa, and then at that point your husband will no longer be eligible. So there has to be we would have to think of a more creative way to help your new husband, whether that's waiting for your residency, and depending on your T visa, we can try to attain your residency faster. Um, there have been some attempts, depending on the severity of your T visa, where USCIS allows us to ask for your residency before the 3-year period. And so you can adjust sooner. And maybe that would be the best method to help your new husband, depending on how long your U visa has been pending and the fact that you can't add him to your T visa because it's already been approved. So I would reach out so we can do a great analysis, see how he entered. Maybe he has his own T visa, and maybe that's faster to do his own T visa. There's been a lot of new laws that came out on T visas, and some people that think that they're not eligible are actually eligible for a T visa. We're learning a lot through just the new laws that are coming out and new decisions that are coming out from USCIS. So it really helps us help more clients. And so just depending on his background, I would definitely call for a consultation with him on the line, and we can like go over everything and see if how we can help him the best way. And we'll give you the options. We'll say, this is what this will lead to. This is what this will lead to. This is what this will lead to. And then at the end of the day, it's your decision on how you want to move forward. Our consultations right now are $75. Um, and they're great because you'll be able to sit with us for 30 to 45 minutes and really talk about your case and get all your cases, get your questions answered. So I would definitely call us. We are relatively, we are like on the bottom, like we're one of the, we're from February. So we just opened up in January, February. And we do, if you're in Clearwater, Florida, or you're in Fairfax, Virginia, we can do in person for the 75. We can, or we do Zoom. We love to do Zoom because we want to see your face. We want to have that interaction. But if you want to do phone, we can also do phone. Okay. How long takes green card by VAWA? I'm married to a citizen. I have no criminal record, just one entry. So for a VAWA, it really just depends. If your VAWA is still pending, your VAWA has to be approved before you can get your green card. Right now, VAWAs are taking about 40 months. So that's a really long time. Normally with the VAWA, if you're eligible, you can apply for residency or your green card at the same time, but that green card cannot be approved until your VAWA is approved. Once your VAWA is approved, it'll, depending on your jurisdiction, so depending on where you live, and depending on that USCIS office that's closest to you and how fast they're going through these residency applications, it could be anywhere from 3, 6 months to a year. And depending on what they see in your history, we've had, so we worked for a firm before this where we had a big volume of VAWA cases. And so we were seeing a lot of the data, and the data was really 50-50 if they were interviewing VAWA approvals or not. And it was just, I felt like it was more of a pick and choose. I was the head, Isabel was our supervising attorney, and I was second in command. And I oversaw about 8 attorneys, and I really saw over the VAWA cases. And so I have a really good idea on the processing times and what, the complicated VAWAs were, the simple ones were. And it was really a 50-50 chance if you were going to get interviewed or not. So there is a possibility that you might get interviewed for your residency application after your VAWA is approved. Okay. Okay. If I have the 245I, will my husband benefit from that as well? That's a really good question. Yes, he will benefit from the 245I. We just have to see how long you guys have been married, and what's the new petition based on. So 245I, for those of you that don't know, is like a grandfathered petition. When someone has petitioned you before 2001, or you could be a beneficiary of a petition before 1997, you're able to adjust your status with a 245I. But it's a little tricky because that 245I has to be still usable. Otherwise, you would need a new way to adjust with that 245I. And the 245I is basically a way that you don't have to leave the country to adjust your status. You can stay. Also with 245I, what you need to be careful with is that you need to only have one illegal entry. If you have multiple entries, the 245I will not work. So there might be other reasons or other ways to adjust your status. I've had clients who were 245 eligible, but we've decided to go another route because it was faster, another route, or there was no way for them to petition to get a petition now. And that petition would have to be a U.S. citizen spouse or a child over 21. And they wouldn't have, you can't have any other issues like multiple entries or misrepresentation. You'll need a waiver for those kind of things. Okay. Good afternoon. My I-485 has been reviewing from June 28th. How long does it take to get approved? Very good question. It really depends on where you live. June 28th is not a long time, and it really depends on what it's based upon. If it's based upon a marriage, it's probably going to take about a year. If it's based upon an approved petition, like a VAWA or a T visa, it might take a little bit less because it's already based on something that's been approved. But the I-485, which is your residency or your green card application, has to be based on something. It can't just be filed alone. And depending on where you live, it can take 3, 6, 12 months. If you go on the USCIS website, you'll be able to go and see the USCIS website and go to the case status information where they have the processing times. And then you can input like 485. They're going to ask you what it's based on. You'll put family petition, VAWA approval, T visa approval, whatever it is. And then you'll put where you live. So you're the closest USCIS location to you. I'm in Clearwater, Florida, so that would be Tampa, Florida. And then it'll spit out a number and it'll say that this is usually how long it takes for adjudicating a 485 based on your answers. Okay. JTC services. We were married from 2002, but we divorced for about 10 years and remarried. Okay. So she likely petitioned for you. So if that's the case, you might be able to use the old petition if you never had used it before, and that is the same marriage. That would be that's a little tricky. So I would argue that you can use the same petition from prior to 2001, and you wouldn't have to file a new I-130 marriage petition. But I would really want to look into your history to make sure that there's no other immigration violations that you have to be worried about. Certain waivers require you to show certain circumstances, like if you had misrepresentation, you would, for any reason, and this could be as simple as when you applied for a visa one time and when you were abroad, you told them that you were married when you weren't. They consider that a misrepresentation. You would have to file a waiver with your 245I, your 485, your residency green card application, and you would have to show extreme hardship as to why you should be granted that waiver and remain in the United States. So there's a lot to consider, and before filing something, you should really understand what you're getting yourself into, what the requirements are, what to expect, and that's what we are here to help you do, right? So I would definitely call for a consultation. We can review your case in depth with you and your wife or husband, and then we can see what the best route for you is. Okay. Ok, tenemos una pregunta en español. Mi novia está detenido en Laredo, inmigración, está solicitando asilo. ¿Sería buena ponerle un abogado? Ok, sí, especialmente con asilo. Te voy a decir que asilo es lo más difícil, aplicaciones alguien puede hacer. Y hay datos, usted lo puede hacer por Google, hay datos diciendo que cuando alguien no tiene un abogado con asilo, hay un gran chance que lo van a negar. Pero si tiene un abogado, el asilo tiene más chance para ganar. Por ejemplo, tenemos datos por cada corte de inmigración, cada juez de inmigración. Yo estaba buscando por otro cliente el otro día y hay un juez creo que es en Virginia, y ella tenía los datos que era 50-50 si tenía abogado, que lo van a aprobar, que lo aprobaron, sí, la gestoría, tenía datos de la gestoría, y si no tenía abogado, fue 88% que no va a ganar si no tenía abogado. So, es muy importante, especialmente con los asilos, especialmente con las personas que tienen corte, que tienes un abogado, porque el asilo es la más difícil, y cuando tenemos consultas con alguien que quiere hacer asilo, estamos Ernesto. Hablamos de qué pasó, por qué tienen miedo y estamos Ernesto si es duro para ganar o no y los chances para ganar, ¿no? Pero definitely tiene que tener un abogado si está tratando de hacer un asilo. Okay. Okay, let's see. Okay, Sandra says, I have 45 and I've been reviewing from June 28th. How long does it take? Okay, so marriage-based in Washington State. I can check real quick for you. But it's always good to know that you can go on uscis.gov and go to processing times, form 485. I wish I could share my screen, but I can't. Family-based in Seattle. Right now, processing times are 14.5 months. So that's about a year and 2 months. That's how long it's going to take on average. Okay. What if someone reports an asylum fraud and they have their appointment in a week? Okay. So I'm assuming that asylum fraud, meaning you submitted a claim for asylum and it was a lie, right? And the best thing to do would be to withdraw your asylum application, whether that be in the appointment or writing a letter prior to that appointment. If you don't have an attorney, I wouldn't necessarily go to that interview just in case they try to really try to get the answers from you as to why you're withdrawing. But I would send a notice like today to try to get to the asylum office and wherever your receipt notice, you'll have a receipt notice that says the address. I would send it to both places asking to withdraw your asylum claim, and do not give any details. Just say that you want to withdraw it. What they're going to do is they're going to consider it abandoned instead of stating that you were fraudulent or frivolous in your asylum claim. There is a chance that they might put you into proceedings. That's a big chance. That's happened to clients before. So Beatriz, I would really call and schedule a consultation so we can get a little bit more information about what kind of fraud was placed on that application and who committed that fraud. There has been a lot of instances with our previous clients where a notario submitted an asylum claim without their knowledge, and there was falsified information on the asylum. And so we were able to use that as reason why we're withdrawing and trying not to bring attention to the fact that it's fraudulent and that it was taking it off of our of your responsibility, like it wasn't your fault. That would be the best thing to do, is really to deter responsibility from yourself if that was in fact someone else who submitted it for you. There's a lot of fraudulent notarios out there that are doing this just to get a green card, and unfortunately what they don't understand, or what they don't care to inform the clients about, is that if you submit a fraudulent asylum application, you will be deported, right? That is one of the big no-nos for immigration, is marriage fraud. There's almost no coming back. Asylum fraud, and obviously committing any serious offenses like aggravated felonies. Okay. My brother has to renew his green card, but he gets DUI 4 years ago. DUI, I'm not concerned about. DUI is fine. What I would be concerned about is the seriousness behind it, though. Was it an aggravated DUI? Was someone killed or badly hurt, like a victim was hurt in that DUI? That's where I would look into. But if it's a DUI, he got stopped, no one was hurt, maybe a little bumper traffic, then he should be fine to renew his green card. So 50-50, no way. Um, yes, asylum is really hard to win. And there's a lot of times where you're submitting an asylum application. Um, and maybe some attorneys are not honest with their clients, but we're honest and we'll tell them if this asylum is weak or strong. And it's their opportunity, right, to, or their decision if they want to move forward with the case or not, even though it is weak, right? But it might be this person's only way to try to remain in the United States. So why not try? But if you do not have an attorney, the percentages are really high on getting denied because there's just a lot that goes into asylum. You have to know what your state is saying is enough for asylum and what's not, because yes, asylum is international, but the U.S. has their own laws that redefine what asylum means in the United States, and then within the United States, the sections of states have their own laws as to what they define asylum to be, sufficient or not. So, for example, I'm in Florida and my business partner is in Virginia. Over here, one of the elements that you have to prove is persecution, or past persecution. And in Florida, death threats are not enough for past persecution. However, in Virginia, death threats are enough and are sufficient. So, being that that is one of the big things that you have to prove in asylum, and that it differs between Florida and Virginia, that's how you know that asylum is really difficult to understand, and you really have to know, and you really have to be an attorney, right, to get this right. Okay. They don't know. Okay, so Beatriz talking more about the asylum. They don't know they have been reported. Okay, so you're saying that they have been reported for a fraudulent asylum application. Alguien los reportó sin dar más detalles o le dijeron que es una mentira, pero hay posibilidad que los dejaron entrar o podía esperar a que llegue el día de su corte. Ok, hay diferencia de corte y una cita de asilo afirmativo con el oficial de USCIS. So, en una entrevista normalmente dice que tiene una entrevista con el oficial de asilo, la oficina de asilo, que está en su área. El corte es algo diferente. Corte es más serio. Si está haciendo asilo en corte, tiene que enseñar que no fue fraud, que no fue mentira, y eso es gran para hacer si no tiene un abogado. Si el asilo es de verdad, y alguien dijo al juez que fue mentira, el juez va a decir que eso es serio para ellos y van a tratar de investigar durante su cita, su día de corte. Y si no tienes abogado y tiene un juez y un abogado del gobierno preguntando usted preguntas de si su asilo fue de fraud o no, it's intimidating, ¿no? Es algo muy serio. So, por favor, llama a nosotros para ver cómo podemos ayudar o a dar más información para tener en su mente qué quieres hacer, ¿no? Pero eso es algo muy serio. Ok, tenemos una pregunta. Tengo 19 años, entró aquí a los 16. ¿Qué puede hacer? Ok, Steve, depende en qué país está ahora mismo, porque algunos países pueden ser, todavía tiene tiempo para hacer el visa de juvenil. Pero depende de dónde vive. Por ejemplo, si vive en Maryland, puede ser el visa de juvenil hasta 21 años. Pero si vive en Florida, ya terminó eso. Tiene que tener menos de 18 años para hacer el visa de juvenil. En la visa de juvenil dice que uno de los padres suyos lo abandonó o abusó y todavía está en el país o no está con usted, ¿no? Y tenemos que enseñar al juez o el juez de familia que tiene alguien que puede ser su guardian en esas situaciones. Y durante ese tiempo, el primer paso es el corte de familia le va a dar un orden de predicate order y con eso podemos aplicar por el visa de juvenil con inmigración. El visa de juvenil le da la oportunidad para quedar aquí sin deportar por algunos años y después de algunos años puede aplicar por la residencia si tiene todo bueno, si está pagando los taxes, si está una buena persona, no tiene ese arresto serio de criminal. Y también después de ser aprobado el SIGIS, el visa de juvenil, puede obtener un permiso de trabajo y puede trabajar. So, Steve, si quiere llamar a nosotros para hacer una consulta, eso es algo que sí hacemos por los clientes. Hacemos mucho visas de juvenil y podemos ayudar. Ok, solamente tengo una más tiempo para una más pregunta. Ok, mi fecha de probabilidad llegó en julio. Envié el 45 EB4. ¿En cuánto tiempo me pidieron el I-860? Ok, si estás hablando de Visa Bulletin. Ok. El EB4, perdón, el EB4 es un visa de empleados y nosotros no hacemos los visas de empleados. Eso es algo que algunos abogados hacen, los visas humanitarios de la familia o de deportación, o hacen visas de negocios. Y el EB4 es un visa de negocios. Mi recomendación es que llama a Villar y García. Ellos están en Texas y son amigos, muy buenos amigos de nosotros. Están en El Paso, Texas. El número de ellos es 915-314-2363. So, 915-314-2363. Villar y García, Immigration Attorneys, están en El Paso, Texas. Villar estaba en uno de los lives de nosotros el otro semana y están buenos gente. So, si quieres, llama a ellos para más preguntas si necesita ayuda con la visa de negocio. Pues es el único que podía responder. Perdón, no tengo más tiempo. Pero estamos aquí todos los días por los lives. So, síganos en todos los social media.